I'd like to call the City of Wheat Ridge Planning Commission for January 16, 2020 to order. Can I get roll call members, please?
Melissa Antle,
Present.
Will Kearns,
Here.
Daniel Larson,
Here.
Janet Leo,
Here.
Scott Ohm,
Here.
Richard Peterson, Jahi Simbai,
Here.
Vivian Voss.
Present.
The next order on the agenda is the Pledge of Allegiance. Please rise. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Is there a motion to approve the order of the agenda?
So moved.
Can I get a second? Are there any additions or corrections to the agenda?
I do have one resolution that we forgot to put on there that we have to adopt every year about legal notice. We can do that under new business, but if you don't mind just acknowledging that addition, appreciate it.
Yeah, we can add that.
Thank you.
I don't know that we need a motion on that, do we?
That's fine. Yeah, the order stays the same. We're just
Okay.
going to add that.
Okay. Let's call for a vote.
Motion passed 8-0.
Is there a motion to approve the order of minutes for December 19, 2019?
I will make a motion to approve the minutes of December 19th, 2019.
Is there a second?
Second.
Any discussion? Call for a vote.
Motion passed 7-0 with one abstaining.
I will now open up the public forum. This is the time for any person to speak on any subject not appearing on tonight's agenda. I see nobody in the audience, so I will close the public forum. I open up the public hearing for case number ZOA-20-01, an ordinance amending Chapter 26 of the Wheat Ridge Code of Laws concerning residential group home and substance abuse clinic zoning requirements, and ask for the staff report.
Thank you. Good evening. We're just going to make that report from the table here tonight. We don't have any slides. You know me, Lauren Mikulak, Planning Manager with the City of Wheat Ridge, and with me tonight is Jerry Dahl. He is our City Attorney. As noted in our staff report, the group home ordinance has been unchanged for the last 20 years or so, and the recent establishment of a couple of new group homes is what brought the topic back to City Council's attention. Because there's also some relationship to federal fair housing law, the City Attorney's Office has taken the lead in drafting this code amendment because it affects Chapter 26, the zoning code. Planning staff and you all have jurisdiction over this proposed language. There are a spectrum of sort of group living arrangements that exist in the world. They go under a variety of names. You've seen in our code, we tend to call them either group home, congregate care, or nursing home. And through this code amendment, we acknowledged that we needed to address specifically group homes for disabled people, especially in relationship to federal law. And we're also seeking, whenever we amend a code, to make it more clear, to eliminate redundancies and inconsistent provisions. So we'll walk through that. I'll turn this over to Mr. Dahl in a moment. Council has met twice in study session, and this process has really been a learning process for a lot of us on federal regulations and how they relate to this topic. I'll jump back in, I think, on a couple of the non-federal provisions in a minute, but if you want to walk us through what you can share.
You bet.
Thanks.
Well, Commission, I appreciate your having me again. I always enjoy coming to you, and I always get good questions. It's always a really good dialogue, and I want you to know how much I appreciate that. This is my life, this is what I've done my whole career, and it may be nerdy, but it's what I find really rewarding. And I appreciate also the fact that you do this for love, because you don't get paid. You get the occasional snack, but that's not anything like the same value of what you put in. I don't often have the chance to tell you that, and I wanted you to hear that. Pardon me. We're here tonight to adjust the city's regulations that comply with the Fair Housing Act amendments of 1988. That's a federal statute that basically says that the disabled should have the same access to government programs as other parties. That seems easy, and you think about programs that actually provide assistance, whatever, to various groups of people. But that statute has been interpreted many times, both by federal rule and regulation and by case law, to say that it applies to a program that the city provides here is zoning, isn't it? That's a program. We don't often think about regulations as a program. You think about food stamps as a program and other Social Security as a program. But zoning's a program, and I think that that's true. And you as the Planning Commission, I think, can appreciate that the program you provide, or the city provides through planning, produces a result and produces benefits to citizens, doesn't it? Just like food stamps does. As a citizen, I know that if I'm in a residential zone district, I'm not going to have a tannery next door. That's as a result of your zoning program that the city provides. And that's an easy example. And because you're on the Planning Commission, you see all these various applications. Think about the fact that that actually is a program that you're administering and that the city is providing. And the case law is clear that the Fair Housing Act amendments, and in their protection of the disabled, also extends to the implementation of a zoning program on the local level. That has meant, and the case law is pretty clear, that group homes for the disabled are entitled to the protection of the law and the access to that program. And that's why we're here tonight. And let me describe how that access is. That access provides, or the city has provided, and I'll tell you in a minute how we've done it since 1996 and how where it's being recommended to be changed. But most persons, of course, in the city have access to be able to live in a residential zoning neighborhood, despite the number of people in a family. My father was raised in a family of 13 people in 13 kids in northern Minnesota in the Depression. That's a lot of people in a home, isn't it? Probably much larger. In fact, that's more than the 8 that we'd allow group homes here. Why do I even mention my family in that whole example? I mention it because the base rule that we're trying to apply, and that these regulations, I believe, do apply and accomplish, is the treatment of group homes for the disabled as much as possible in the same way that you'd treat that family, that Norwegian family. Would you tell them how many cars they could park on their house? No, of course not, if they moved in here. Would you tell them the hours that they could come and go? Well, you wouldn't do that, would you? If you're going to tell a group home for 8, and that's the number we've suggested, and there's good reasons for that. Okay, here's the number of cars you can have. Here's when you can come and go. You're not giving them access to that program in the same way as you're giving to other natural persons, correct? And so I use this kind of odd analogy, which hopefully at least it captures your attention, so that we can then use it to kind of bear that in mind. Would we do that to Jerry Dahl's family? That family of 13, I think 3 died in infancy, so okay, now you have 10, but still. Would we do that to them? Why are we doing it here to these people is the sort of thought process that I'd like you to bear in mind as we go through. So the Fair Housing Act amendments basically say we're trying to be supportive of and allow equal access to these various programs. And persons that are developmentally disabled, recovering, drug addicts, alcoholics, not currently using. The law is very clear that the addiction is a disease and is a handicap, so long as it's not a current, it has to be a recovering, but not currently using, that these people are handicapped within the scope of the federal law and entitled to this access. And that access is to be able to live in a residential neighborhood up to a certain number of persons in the same way as that Norwegian family would, because that gives you the ability to recover in a residential setting that is as close to a normal family setting as possible, as opposed to an institutional setting. Enough on the lecture about the Fair Housing Act amendments, but that's the landscape of the law and the structure of the law, and the case law is really pretty supportive of that up to a certain number of persons, and that's kind of where the art is, and we'll describe that. What has the city done to comply with this? I was aware when I was first hired by a city attorney in 1995 that the city then had, in the Code of Laws, had a requirement only one group home per for council districts of 4 in the city, and a special use permit required, no matter what size of the group home. And I advised the council that's quite likely in flagrant violation of the Fair Housing Act amendments. One of the tenets of the case law emerging from the Fair Housing Act is for a reasonably sized group home, subjecting that home to a special use permit review places them in a setting, and that review would take place here. So you've got the applicant for the home, and you have a room full of people saying, we don't think those people ought to live next to us, and it's a public setting that you wouldn't apply, would you, to that Norwegian family? Oh, you've got 8 kids? You're going to need to get a permit for that. Now, above a certain number, yes, and the number we've chosen is 8, and I'll describe it for you. But in any event, to rocket forward 25 years from 1995, I told the council in 1995 that, that's in flagrant violation of the Fair Housing Act amendments, a couple of fixes. And the fix the council chose then, which has been in place now for 22 years, is to amend the definition of family in the code, where if you're a family, you're allowed, aren't you, as of right in various residential zone districts, to include any number of persons who are handicapped or disabled under federal and state law, and a fair amount of language around that. And that's actually worked pretty well, but there was no upper limit. But it did bring the city into compliance with the law, but there was no upper limit. And I told the council at the time, you can have an upper limit, and there's some other things you can do. And in 1996, they chose to just at least do the family definition fix. And a number of cities do that. You're not alone at all. There are many cities that you do that as kind of the quick Band-Aid that solves the problem, and until they see other issues, it's okay. And that's served the city, I think, pretty well for that amount of time, but not presently. In any event, that's the old regime, and that's what we have now. In terms of the changes that are in the ordinance, and you can turn to specific pages, but I'll just stick with the staff report to you, and let me identify some of the things that then we have done and the alterations we've made to address group homes in a little more detailed, I think, rigorous fashion, in a way I think is more protective of residential neighborhoods in the city of Wheat Ridge than the sort of one-size-fits-all family definition that we've relied on so long. First, we've created a new definition of residential group home for the disabled to include persons who are handicapped or disabled as defined by federal state law, enabling us then to move that awkward language out of the regular definition of family, because we don't need the family definition to do that work anymore. We now have a definition just for a residential group home for the disabled. That's the first thing we've done. Secondly, we've created in this ordinance, as it says, a regulatory scheme under which all residential group homes are regulated in the same manner, and we'll be able to parse into the individual zone district use charts so you can see where they're allowed permissively and where they're allowed by special use permit. So we have done that. We've, in those use charts, and I'm on number 3 in this little bullet point list in the staff report, amended those charts to distinguish between group homes of 8 or fewer, plus required staff, 9 or more, and then 15 or more. And so there's really 3 categories now. And I'll tell you right now that the 8 or fewer, including necessary persons involved in their care, is established as a permitted use in residential districts. It's established as a permitted use in the same way regular single-family homes are. And so that's the protection, and that's the base compliance with the Fair Housing Act amendments. Why the number 8? The Fair Housing Act amendment doesn't give you a number. It just says you should provide this. At some point, in all the cases, all the federal cases primarily, agree that at some point the number of persons has rendered the facility an institutional use. and a hospital or an institution that can and should be treated by local governments differently than a family home. The art is in where that line is crossed, and I'd love to tell you that the federal statute says it's this number, and it doesn't. And there are cases saying, you've got 12, that's okay. Your limit of 12 is all right. There are cases saying, the numbers vary, but I won't say a majority of jurisdictions are in between 8 and 10 somewhere, because that's kind of our concept. My father's family is rare anymore. You just aren't going to see that number of children. But in between 8 or 10 tends to be a pretty good middle ground. And importantly, Colorado has a state statute that recognizes the ability for local governments to treat, or actually requires local governments to treat group homes for up to 8 developmentally disabled persons as uses by right in residential zone districts. In fact, requires that. That's a safe harbor for the city, because you've got some guidance from the state statute. You're doing what the state statute says, and I believe that what the state legislature was doing when it came up with that number was trying its best to find that sweet spot that complied with the federal law but did not end up injecting really large group homes as a use by right in residential zone districts. So yes, there's an art to it, and if you said to me, well, if we decrease that number to 6, what do you think? Or can we increase it to 12? Yes, you can do all of that, and you could probably find a case. But if our goal here is to comply with the law in a way that's fair and to reasonably protect the city in terms of exposure, that's, I think, a number that has good numeric sense, it has, I think, good social sense, and it has some backup in a state statute. So it gives you a little cover, and it gives you people that are on your side in the form of the state legislature. I would be comfortable defending that, because I'd be able to tell the judge, Your Honor, we did our best. And we looked at what other jurisdictions did. We looked at what the state has done. We think that's a good model to follow, Your Honor. So to say we're wrong, the judge would have to say the state legislature's wrong. And I like that kind of cover. So I know that's a very critical number. It's a critical number to your constituents. It's a critical number to residents. And it's a critical number to families that would be living next door to a group home. And that's why I wanted to spend the kind of time on that number that I did, but I believe it's supportive of and complies with the law. We did then break it out. If you're 9 to through 14, that equals special use permit in those zone districts. And I believe that also is defensible under the case law, because at some point the impacts of a group home exceed what you would see even from my father's family of 9 kids. And at some point, you are enabled to say that's a special use permit. And from 9 through 14, we've said special use permit. 15 or more are not permitted at all in residential zone districts, whether it be, I'm looking at bullet point number 3, which has got a lot in it. I mean, that's really the heart of this whole thing. And we've considered them more institutional in nature, and you'll see in the use charts that that's where they're permitted. Point number 4, we eliminated, as I said, the portion of the definition of family that did all this work, because now we've done it elsewhere. We also tinkered with the current definition of family. There was this weird little gap. We had this exclusion of 4 persons over the age of 60, because the current family definition allows groups of 3 unrelated, and then 5 unrelated persons over the age of 60. But what about 4? We think that was some kind of odd mistake. So while we were at it, we kind of shortened that definition, made it a little easier. Point number 5, I think I've already mentioned that the most ordinances that put a limit on the use by right category, for us that's 8, also say, and such additional persons as required for the care of those persons. Often I'm asked, well, that means a whole lot of staff, and that could mean a lot more people. And the point that the memo makes, and that I've seen in practice, is the economics of running such a home. Personnel is a huge cost. We all know that. Those of us in small business know your biggest cost is personnel. And we're pretty confident that just the economics of operating a group home are going to account for that and are going to keep that number as low as it needs to be to still take care of those persons. And the case law does say that you need to be able to provide for persons involved in the care of the disabled persons of whatever category. Bringing me to a couple of other things that we have done while we were at it, and I'm up on number 6 in the little staff report, and Lauren has kindly agreed to take on the next couple, and then we'll get back to my part.
Sure. So group homes deal with treatment or care, residential care of a collection of people. We also have references to residential treatment in our definitions of substance abuse clinics and just traditional clinics. The challenge that we have there is we have some conflicting language and confusing language when you look at the definitions and the use charts. And they try to make a distinction on residential or non-residential and try to make a finer distinction between alcohol abuse and substance abuse, which based on when we get proposals for these types of uses, we ask them to provide a written description of what they're doing. And we're having a really hard time interpreting sort of the buckets that we're creating in the zoning code. So in short, what we have done is disentangle substance abuse clinics from regular clinic like marriage counseling or regular therapist. We've always allowed substance abuse clinics as a special use in C1, C2, and a permitted use in IE. We're not changing that. We're just clarifying that we think of substance abuse as all-encompassing. It could be alcohol, it could be drug, it could be whatever it is. I'm not a subject area expert where I should be deciding is that alcohol abuse or substance abuse. So we've disentangled those two, substance abuse and regular clinics. That addresses number 6 and number 7 in this list. And then number 8 is a parking requirement. As we've mentioned, if we're trying to treat group homes like single-family homes, then the parking requirement for smaller group homes would be consistent with that of a traditional single family. So that's 4 parking spaces, can be all on site, can be 2 on the street, 2 on the driveway. Because we have that special use cutoff at 9 or more, we can require more parking for those larger sizes as a condition of approval through the special or conditional use process.
And obviously, we'll have, as soon as I'm done, then we'll take on the questions, and I know that you will have them. I know you won't disappoint me. I'm on number 9, and this is fairly important. We have devised in this ordinance a requirement for a semi-annual certification from the operators, right, in the current draft of operators group homes only for the disabled, that they confirm the homes in conformance with various requirements. Most importantly, are the persons in the home disabled? Because if they're not disabled, they're not entitled to the benefit of the ability to have 8 unrelated persons in a home as a use by right in a residential zone district. You can't do that here unless you're in this protected class that has protections under the Fair Housing Act amendments. And all the jurisdictions that I represent and have represented, I do a lot of special counsel work in land use and helped to rewrite the El Paso County regulations on group homes a couple of years ago. And all of the jurisdictions, El Paso County included, really have raised this issue of we know it's a business for these group homes are a business. Why can't we be requiring a business license and inspections, and we're going to show up just like we show up at bars to find out if people are being served after hours or over service or underage. And we want to be able to do that because we want to be able to do that. I have consistently pushed back on that because I've said, fine, you're asking my father's family any of those questions? Any of those questions? No, you aren't. So you really aren't. If you're asking all those questions, you really aren't providing, are you, the program of zoning equally to the disabled as you are to my father's family of 9. No Norwegians here besides me, right? So I'm safe. Do you mind of us using? The Norwegians don't mind. You know, they never mind about these things. Thank you very much. I appreciate it. I should have known that. ON, yeah. So in any event, The best answer I've been able to give to what I will describe to you as a lot of pressure to put like a reporting and licensing regime on a group of people that otherwise I believe should be treated, when we're talking at 8 and less now, should be treated no differently than the Norwegian family. The best I've been able to do, and as far as I've been comfortable pushing back on that, is to say, okay, there probably is a proper governmental purpose to have a report that says, yes, we still are entitled to the protections that for this group that are not available to just a whole bunch of just unrelated persons. And for me, that is a self-reporting form that identifies the key issues, and they're in the code. And we've put together a draft of that form. And that's as far as I've been willing to go. Now, there are a couple of cities out there that require a business license, and I don't support that. The Department of Justice put together a several-page guidance for local governments saying, look, that kind of requirement is suspect under the law, and the last thing I want to do is have a business license requirement that's suspect. So this is sort of business license requirement light, to be very honest, and it's a kind of a construct, but I think it's helpful because at least it does signal to the group home operator, I need to regularly affirm that I'm entitled to these protections. That's a pretty low bar, and it's one that doesn't make me very uncomfortable in a lawsuit challenging why is the city requiring this. Wouldn't require any of that of the Norwegian family, and I think it's fair for me to say, Your Honor, we at least want to make sure that on an ongoing basis, the home is entitled to the protections which we agree we should provide under the law, but we want to make sure they're entitled. In discussions with staff in the last day or so, we've thought about whether there's any reason not to broaden that requirement to all group homes. And I think that actually we should, because in a sense, to say group home for the disabled, you got to file a report. Group home for elderly, for children, no, you don't. Honestly, I think it's better if what we're trying to do is, the issue should be the same, shouldn't it? Are you entitled to the protections and the advantages that the code gives you for your category? Tell us that you are. There was a big debate at council at study session last week about how frequently to require those reports, and they ended up at semi-annual rather than quarterly. And there was a lot of debate about it. You could certainly make a different recommendation to them, but that's where they ended up. I'm sorry to spend so much time on that, but I wanted to make sure that you didn't catch me up and say, wait a minute, you told us at the beginning that these people should be treated the same. This isn't treating them the same, is it? Because it's a regulatory requirement that Norwegian family doesn't have. And I've said I'm doing this to kind of respond to the pressure that there's a suspicion, I think, that people would try to misuse this entitlement. So I think it is, I'm comfortable defending the fact that you should be able to at least identify on a regular basis that you're entitled to the entitlement. And I'm okay with that. We're almost done. The state statute, interestingly, that also says 8 persons developmentally disabled, that one, also says, it's over in Title 30, believe it or not, which is the county title, but it applies to cities as well, allows local governments to prohibit meetings or gatherings on site that are inconsistent with the activities otherwise permitted in the zoning district. And that addresses meetings. You can certainly have a meeting in the group home that's an Alcoholics Anonymous meeting or any other kind of meeting that's just for those residents. But and there have been circumstances like this around the state and around the country, if you're inviting other people and now it's a session that includes ministerial activities, that includes counseling and treatment where you're bringing professionals in. Let's remember, the whole purpose here is not to create a clinic. The purpose is to create access to a residential zoning program that is as close as possible to living as a family in a residence, not the whole panoply of treatment activities and services that the disabled and recovering alcoholics need. I get that, but it does not have to take place in the home, because that transforms the home outside of what they're entitled to, which is same treatment as a family. And families don't get to create whole treatment programs and effectively a clinic operating. And so that is why I was glad to see that language in the state statute. Again, it gives me cover because the state legislature has recognized that. That's why you have number 10. Number 11 is the last item, and the Fair Housing Act amendments say, look, your regulations need to address this and give an equal opportunity to access this program, and they should also provide a procedure for a reasonable accommodation if in a specific fact pattern case your rules don't serve the goal of the act. Kind of basically a case-by-case board of adjustment kind of variance process that's very case-by-case that you can't write in. Someone might say, well, we realize the number is 8, but in this particular case, we think 9 is a reasonable accommodation for these various reasons, or we believe that we should be allowed an additional parking space or one less or something like that. And what I did was I stole the reasonable accommodation procedure, which is administrative review and procedure, from Prescott, Arizona. We had some testimony in front of the city council a month or two ago on this topic, and some residents came in and said, you should look at Prescott, Arizona. They've got a great ordinance. We did look at that. They did have a good ordinance. It got repealed in September of last year because the state of Arizona took over the regulation of group homes from municipalities, kind of a devolution up. Usually it's the other way, but okay. But while it's repealed, the tool on reasonable accommodation I thought was well written. It doesn't work to use the Board of Adjustment because the variance standards that we have in our code for Board of Adjustment don't lend themselves to a reasonable accommodation for a person with disabilities in a particular circumstance. And so I went with the Prescott approach. Thank you for your patience in listening to this long description. This would be an important step for the city. The city's gotten by, but as group homes, and I think there's more interest in pressure for group homes, I think the city should be prepared to make reasonable distinctions between the kinds of homes that we get and the sizes, and reasonable regulations that are not out of line with what others are doing in the country. And while someone can always, I say, can we be sued? My standard answer is anybody with the price of a filing fee, what if $225 at Jefferson County District Court can sue you. The real question is what happens then? And what happens then is you tell a story to the district court judge, which is the story I just told you of the ordinance that you have. And I think that's a good story. It's a defensible story. Thanks for your patience. Now's the time for questions, and I'm sure you have them.
Thank you.
So,
Commissioner Kearns?
A couple of questions, because in Melissa and I's district, there's a number of elderly group homes, especially around the hospital. And what I see here is there's parking restrictions, and there's it looks like there's some spacing restrictions, and I'm assuming that's because we're trying to distribute the impact that the group homes have on the neighborhood. Is that correct?
Yeah, so what we didn't cover is sort of why do we have group homes? And it really stems from federal policy shift in the 1960s to deinstitutionalize. So you think about when you used to hear people get sent to the mental hospital, or you have these huge nursing homes. The premise being that you get better outcomes for residents, whether it's elderly or disabled, in a smaller setting. But if the goal is to deinstitutionalize, then it doesn't mean you have a block full of group homes in a residential neighborhood, because that defeats that purpose. So the separation requirements have been existing in the code for quite some time and are in the spirit of that, sort of separating and sort of diffusing this land use throughout the community.
The the distance separation, and I don't know where I saw it. It's in here somewhere, but it was, I think, 750 feet for a group home with eight or less, and then 1,500 feet for a group home of 8 or more. But that's in a residential one zone district, or
It's any residential district.
any
Yeah,
residential?
we have 750 right now, and that applies universally. The 1,500 is something we've added now that we've identified another group of sort of this larger group home classification.
Does it matter if there's existing multifamily uses within that sort of distance?
No.
No. What is trying to be accomplished here, and again, it's a restriction. You wouldn't necessarily say you can't have 2 Norwegian families, within, sorry to keep using it, but it's a handy tool, isn't it, for our purposes? I think it is, whatever. The idea is that you get to have access to a normal residential environment, and if there's 3 group homes in a row, that's not as normal a residential environment. And so that, to me, allows you to require spacing requirements, which otherwise would be, you go, well, why is that special to a group home for the disabled? Yes, it is, but it doesn't violate Dahl's overall rule, because it is in aid of making the setting as normal as possible. Your point, I think, is a fair one, which is, well, if there's multifamily, isn't that the same kind of density next door to the group home? Yes, it is. It's not density of group homes for the disabled. It's density of single-family residential. And while that just means that particular area is a little higher density, but it's allowed of right, likely. And so we don't take into account sort of the non-group home density in the area. I think as far as we can go here is as I've said.
I have one more question, and that has to do with, I see sex offenders are included in this, and that each group home would include 1, but not more than 1. And is that a function to also distribute the impact of sex offenders in the neighborhood?
Very, very fair question. There's a state law that frankly prevents more than one sex offender to be, unless related by blood marriage or adoption, in a home, and that includes the residential settings, regular residential settings, separate and apart from the group home context. And it was important that because this, and that's just generally true. As you might recall, 10 years ago, there was a fair amount of regulation and litigation around where registered sex offenders could live, and communities started to create zoning exclusion regulations to try to exclude sex offenders from their jurisdiction. Then that just pushed them to other jurisdictions. But we ended up with a state rule that says 1. We wanted to make sure that in these group homes that wasn't sort of a loophole, that you ended up with more registered sex offenders in a group home, just because it does allow unrelated persons to live together. And so that was kind of a carryover. It's not intended to be sort of a sex offender dispersal mechanism, although your question's a real fair one, a reasonable one. It's designed to ensure that the state rule of no more than 1 per basically residential household gets applied equally to group homes for the disabled. So in that sense, you're treating them just like you treat other living arrangements.
Okay, thank you.
Sure.
That's all
Yep.
I had.
Commissioner Leo?
Yeah, if there were 8 people who were not disabled, and they wanted to live together to share the rent, would there be any restrictions on them?
Yes, there would, because the city, as almost every city in the state, has a upper limit number of the number of unrelated persons that can live together as a use by right in a residential zone district. And those numbers vary because they're allowed to in the non-disabled context. And in the city of Wheat Ridge, it's
Yeah, it's no more than 3
no
unrelated
more than
people.
3. I think in El Paso County, it was no more than 4 or 5. And that's the, college students sharing a house, right? In Boulder, I think the number might be bigger, but they've actually got their own, university towns tend to have a zone district that actually, I think fairly and reasonably responds to that housing need. But in a suburban community like Wheat Ridge, it's not uncommon to see 3 or 4 as the upper limit number for unrelated persons that don't otherwise have a protection like disability.
Right.
That's a common restriction, and we see the need for enforcement of that rule in the city regularly, and the city does enforce it.
So, okay, well, that's good. That answers my question on that. So if it's a permitted use, they still have to apply, or how, or do they just have to report that they're doing this, or is there an application, or how does that work?
Door number 2, right now, just a report, because permitted use, when the Norwegian family wants to move in next to you, they don't have to ask the city's permission, do they? They just show up. Same thing's true here with the caveat that we're requiring the semi-annual report. In practice, what will happen is, half the time, a potential operator of a group home will inquire at the city, what are your rules for this? They'll be, informed. That doesn't prevent 8 disabled persons from occupying a home without telling the city. They are a use by right, just as those 8 Norwegians are a use by right. They don't have to tell the city they're moving to town. The disabled individuals, because they're unrelated persons. The Norwegians are related. They're a family. And that's an exception to this 3 rule, right? And we all know that. I've a rule that any meeting I go to, about half hour after the meeting starts, right? That every meeting I go to, every single one here. So the difference here is that those 8 people are getting the ability to live 8 unrelated persons in a setting where they wouldn't otherwise be able to, because they'd be limited to 3, and so it is reasonable for the city to ask them to tell about that. What will happen, we believe, in practice, and it's what it's a very good question. Council kind of asked a question around that. They said, well, how are we going to know, and how do we even know to tell them they've got to do the report, and shouldn't we write that? I think it was Councilmember Urban's question, and he was, I was pleased he took the following answer from me, and he said, okay, I'll go with that. And I said, I think that we should try this. This is more a process than an event. Very often you write an ordinance and you're done. Here, I think, frankly, we'll get certain feedback, and I'm certain there might be some additional tweaks after 20 years. There ought to be some tweaks necessary, especially around the how does this get applied, and how do people know? I think it's not a huge community. I think it will become known where a group home is, and it will be then fair for the city to send a letter to the residents at XYZ Street saying, hello, we believe that you're operating group home. You need to know we do have rules, and the limit is 8. There is also a requirement for this report. Here's a copy of the form. And we've developed a form, it's still ongoing, we've developed a form that way they don't have to sort of create their own report, and council was insistent on this, that we try to, make the form as easy to complete as possible, but then they're kind of on the radar screen. And I told Councilmember Urban, and I'm telling you, that I expect that may be one of the areas where we see whether it's working well or not, and we have to do a little tweak. But I said, rather than figuring out the tweak ahead of time, let's wait and see how it operates, and then we'll know what problems we really have to solve, if any. But very perceptive question. Council was all over that, and I'm glad to see that you are too.
Okay, I have one last question. Most of the time, at least from my knowledge, a group home, say for the disabled or the elderly, it's usually for a long period of time that they live there. In the case where they are, say, recovering addicts or something, where they're not using, which is what this says, but that would probably be a shorter term. Is there anything that defines, say, the residential setting as far as time? If someone, can there be turnover every 2 weeks or something like that? Does that fall into the right category?
Really good question, and you've identified the key or a key distinction between group homes for recovering alcoholics, addicts primarily, and other disabilities where the residence of individual identified persons is longer, whereas in a lot of group home treatment or sober living arrangements, sometimes they're long, but there's turnover, and the code does not require that there be a certain minimum or maximum residence length, because those persons are entitled to the benefit of the law no matter how long they are there. While they're there, they're entitled to the benefit of the law. Now, the council reasonably asked, as you have, well, how do we know when there's turnover that the replacement person is in fact handicapped or disabled? And could you have the situation of where people start turning over and now it's people that are not disabled under any definition? In part, that's why we think the semi-annual report is helpful, and I realize it's semi-annual if we're more often, but there was a little bit of discussion, Lauren might remember it too, at the council around this, and they came down to semi-annual, where the report will actually say the persons resident are in fact entitled, are in fact handicapped or disabled. And I think the way we wrote this was, and at other times at the request of the city. So we felt that gives the city the opportunity, if they really think that there's been attrition here. Yeah, there were 8 handicapped individuals at the beginning, but we now kind of think there's only 3, and there are 5, college students that are not entitled to this protection, that are not handicapped or disabled. Let's ask them to file a report. And then the council said, well, how do we enforce? And I said, well, if you've got reasonable evidence, then that's a code violation. The fact that it's a home for the disabled doesn't protect it from code enforcement if the residents there aren't entitled to the protection, or not enough of them are there to entitle them to the protection. That would be a case where we would do what we always do in code enforcement. You send the letter, hi, we believe, here's the rule, we believe you're not in compliance with the rule. We're asking you to comply with the rule, and we'll be back in touch. And half of the time, better than that, that's how you get code compliance. But in the tough case, you file the enforcement action. So that's my answer. I get it that there's turnover, but there's nothing in the law of disability and the Fair Housing Act amendments that say that turnover has the fact that you've replaced disabled person A with disabled person B is not a significant fact. The fact that what's significant is the home has had 8 disabled persons and continues to have 8 disabled persons in it. The identity of those persons may change, but the entitlement of the home to the protection of the law does not.
Well, I guess maybe I didn't get my point. Okay. When you have a group home with disabled, and I think of one specific one on Independence, been there for a long time, they seem to become a part of the community. He's used to seeing them. They become a part of the community maybe they don't interact in the same way other people would, however, they are part of that block or that street. When you have recovering addicts, alcoholics, drug, whatever, that, I think the turnover is so much more frequent that they're just there for that period of time, they leave, they're there for that period of time, and, but there's.
No question that they're different, but in my opinion, the city doesn't have the power to deny them the protection of, that you give to a group home where they're there for a long time. Yes, I agree, they're different, they behave differently, and they do, they don't mix well. I don't know if Norwegians do either. It's probably, now our analogy probably breaks down. But the point is, the fact that they're different and there's turnover doesn't change the fact they're disabled and that they're entitled to protection of the statute. And we're doing our best to do that. If you had a home of 9 or more, I'm not saying you could govern how often there's turnover, but in the special use permit context, you might do more things around parking or buffering to kind of acknowledge that in between 9 and 14, there's a lot of activity going on there now, and that's more disruptive of the neighborhood. That's, I think, the beauty of having categories here, and I think the category of 9 and more allows more government intrusion into the way the home is operated. 8 and down, I agree, there's not much government intrusion because at some point you've got to give full benefit of the statute to the disabled, and that's what you're doing at 8.
Okay, well, thank you.
Sure, good question.
Commissioner Vaughns?
Just a couple of questions. The page 9E state that there's a completed application, city manager or designee determines approval or denial. So there is a required application as if it was a business that was opening.
This is under the heading of the application for a reasonable accommodation.
This is,
So, right?
yes,
Page.
number 2.
Yeah, that is not something we'll require of every group home. That's, as I mentioned earlier, where you say, okay, I want to operate a group home for 9 persons as a use by right in a residential zone district without a special use permit. I think you should give me an accommodation for that. And that triggers this kind of like variance board of adjustment in the form of the city manager or his or her designee review. But, and that review, if you're going to ask for an accommodation and a change to what is already a statute or ordinance we believe that's compliant with the law, then and only then can we get into require an application and the kind of detail that's here. Which kind of, I agree with you, walks, talks, acts, and looks a lot like a business license application you'd apply for everyone. No, it's only when they want to do more or less in some way than the code requires.
When a group home for the disabled comes into a residential, is that public knowledge in any way? And is there any citizen's right to protest that?
For a group home that is up to 8 persons as conceived, no. There's no, the city does not publish notice of that, et cetera. For a very good reason. In 1995, when I sat at this very table in this very spot and told the council, look, what you're now requiring is group homes for handicapped or disabled of any number have to get a special use permit, and those people have to come in here and be inquired about. And there's plenty of case law that says that illegally and unnecessarily stigmatizes those persons. And so the answer is no, there's not can the neighborhood protest the use by right? Now, at 9 and up, that's a special use process, And that will be, it's administrative unless there, as you well know, under our system, there's an objection to an administrative special use permit, and then it comes to council. And that's public hearing. And at a larger number, that kind of dialogue is allowed, but not at the smaller number.
Okay. And I'm not aware of how a group home gets established, started. So is it usually a company that comes in and has a residential house that they want to put this into? Or is it like babysitting, where you've got a mom and a dad and two kids, and she takes in 4 or 5 children?
Probably not door number 2, much more often door number 1. There's kind of a wide range. Oxford House, you've probably heard of Oxford House, primarily for recovering alcoholics, is not so much the renter as they help people organize together, if you will, and find a home and work in a kind of a cooperative setting, almost like those college students. Maybe you've got one of them that's more the manager of the place. But, you know, I lived in plenty of houses when I was in college, and while there was a landlord, you didn't see him or her much, and you kind of ran your own show. Oxford House will help recovering alcoholics do that. There are also companies, no question, that will buy or rent a home and then rent rooms and set that up, and that means that you have a commercial business effectively doing that, and I get that, and there's been objection to that. Isn't that a commercial business? Can't we require a business license, et cetera? And you've heard my answer to that, up to 8. Above 9 and up, certainly you can do more. But there's kind of a wide range of how these come to be, but I think it's probably fair to say in at least half of the cases it isn't 8 people that kind of found each other, you know, and rented the house together like college students would. More than half the cases, probably it's some organized system, be it a company or an individual that gathers those folks.
Thank you. One last question. If you suspect that there's a residential home that's being used in that manner, do we get to inquire about it as a citizen? Are we given the answer to whether it is yes or no? Does it raise a code enforcement to check to see what?
We get those inquiries now, so that's part of the reason that this code amendment exists. We are already enforcing this federal fair housing law, but it is not as abundantly clear in the code. So when we've had some of these newer group homes come in the last, I don't know, several months or so, when we get those calls either to planning or city manager or council members or code enforcement, the answer is, it's our understanding, in having spoken to that operator, that this is a group home that's allowed because it's protected class under federal fair housing. And that's all we can say. That's all we typically say. It's a permitted use. We understand your concerns. We'll hear that out. If there's a specific violation in terms of illegal parking or a noise ordinance, the same rules that would apply to you in your home, we can apply to that home. And that's, that answer doesn't change under this new ordinance. It's the answer we've been giving for years, giving maybe a little more often recently, and I imagine would continue to give sort of under this new provision. But we wouldn't be able to say, and here's what they said in their last certification. I wouldn't be comfortable with that. There's HIPAA considerations, all sorts of stuff. So we won't have a lot more detail than that, but that's typically
You
what
just
we
say
say.
yes or no
Yeah.
to the inquiry. Okay.
Yeah, and to that question, most group homes come to us at some point. Most people who want to do something, come and say, can I make widgets here? Can I have a group home here? Can I do this? And so we catch most new folks in the door and have said to them, you don't need a license, you're protected, such and such. So I think the challenge in the enforcement is sort of the Google searching to sweep through, okay, where's everybody right now? Most of the time, new folks come to us, so I don't think we'll have an issue with the notification of the certification, which is new.
Okay, thank you.
Commissioner Larson?
Thank you, Mr. Chairman. I think I've got 3 different issues here. The first one is just a bit of context. And Lauren just mentioned that recently you've been getting inquiries about group homes or possible group homes. First off, has the city ever been found in violation of these, either the federal amendments or anything else? And so then that would lead to the question of, why are we doing this now?
City's not been a target of any federal or local enforcement. The number of inquiries we've been getting has been greater, and I think that there has been, and Lauren can supplement this if I'm missing anything, but I think that there has been greater concern about the sort of unregulated group homes. Council has asked, because they've gotten citizen inquiries and they've directed us to address the issue. I've told them that what you have now is a one-size-fits-all code provision that does not allow you to do anything about group homes of 9 and more. You've got the power to do it, but you have not done that. And so as a result of the pressure, or the pressure and interest, both from the public and from council, that's why we've drafted this. I think it really is time. I've been wondering for the last, now I'm dating myself, 25 years literally, I've been thinking about this, or 24, I guess, and thinking, that Band-Aid sure has been on there a long time, while other communities have done a little more rigorous approach and frankly protected residential neighborhoods at 9 and up more than is presently true for the city. And so I was not unhappy when council said we would like you to look into this. And I do think when, as and if there is a challenge, the city's in a much better defensible position with a kind of thoughtfully designed program rather than a add-on to the definition of family and cross your fingers, which is a perfectly complete description of where we've been for this couple decades.
The only thing I might add, so some of our newer group homes are those that are protected classes. They are disabled populations. And when those homes have located into neighborhoods and neighbors have called council members and said, well, what can you do? Our answer right now is we can do nothing. They've verbally told us that this is what they do, and that's it. So what we are fundamentally doing is we can do something. We can have them semi-annually certify that they are entitled to the protection of being a protected class. So when you get the question of like, well, how do you know, or are you sure there's not more than 8? We now have a tool to ensure that, but that's basically it. That I think summarized with the recent events.
So and this follows up on Commissioner Voss's question on the ability of neighbors to learn about a house on their street, whether in fact that house is a group home. Not even going into the question of can anything being done or they're for or against it, but is that house at that address a group home?
Can somebody ask that question?
Yes.
Sure.
And the answer will be?
I mean, group homes for the elderly and children are operated as businesses, and they do come in with business licenses. So we have that database, and now we would have a certification mechanism by which we could affirm there's a group that's protected there.
If staff finds out that that there's nothing on record, that particular house is not registered as a group home, but
Sure.
there's a possibility it may be, that would then trigger this process of a letter going to would it be the owner or the operator? Where would the letter go?
So we have access to public records, so we would send it typically to the physical address and the ownership address. It'd be the same as if you suspected your neighbor had an illegal home occupation or an illegal shed. We send a letter that said, we ask for enough evidence where we felt comfortable sending a letter that says it has come to the attention of the city that you may be operating such and such, please call me between now and 2 weeks from now. And we sort of go from there.
And if you get no response?
We send it again, or we could send, code enforcement action. At some point, you have to have enough probable cause, right, to continue investigating. But we're not licensing them, so the onus is on them to, again, affirm that they're entitled to the protection. And I don't anticipate that. I mean, most of the group homes we've had have been really great partners, very professional, right? It's in their best interest, too. So that's the kind of thing where we'd address that problem, I think, once we got there, but we're not going to write code in anticipation of that.
And that was the dialogue I had with Councilmember Urban about a week ago, where he was wanting, I think, and with no pejorative, a solution to what we thought might be a problem. And the dialogue, I think, was a constructive one he and I had at study session was, well, often we do that. We say, we think this actually is a problem that we're going to need to deal with, so here's our solution. This is one where we're not completely sure of the nature of the problem. And will it really happen that there will be people consistently and consciously evading this? And if so, what should be our tool? And so we left it that if that happens, we will have to come up with a tool, but any tool we invented now might not really match up with the problem. So, and I put, with fairness, I put that in this category.
Okay, all right, fair enough. And then finally, how will, for the existing group homes that you're aware of that will be they will be required to self-certify then, starting after the ordinance goes into effect?
There's
Yeah, look at section 14 of the ordinance, and group homes for up to and including 8 should come into compliance with the requirements of B1, which is the certification, I think, within 6 months. And, we'll send out information. Group homes 9 to 14 have to apply for and obtain a special use permit, special or conditional use permit, within, I think, that same period of time, 6 months. Group homes in existence on the effective date which don't meet the separation requirements are permitted to continue operation. That's pretty classic approach that we do for basically legal non-conforming uses, and then you default to the legal non-conformant, the abatement of legal non-conforming use standards that we have. Okay. So that's a good question, and that's kind of the phase-in system we came up with.
Okay. And then one more question, Mr. Chairman. As part of the certification, when the operator of the group home completes the form that they're going to need to complete, are the residents identified as individuals, or are they simply resident 1, handicap, resident 2? How you sort of enumerate that?
Door number 2, we're still working on the form, but there's no way that I'll advise the city identify that person is disabled because they're a recovering alcoholic and here's their name. And that's wrong, and I will never let the city do that. But it is fair for the city to ask the owner-operator of the group home to say, there are 7 persons resident in the home and 1 caretaker, and the persons resident other than the caretaker are in fact handicapped or disabled under federal or state law. And that we
without
can
having to identify them any further?
That's correct.
Okay, thank you.
Yep.
Commissioner Antle?
Sure, I do have a few questions. First, I guess, did you do any kind of trend well, I guess we don't really know how many group homes we have, is that correct?
Yeah, I think that's fair to say. Not many.
Yeah, I mean, so I live, kind of a couple houses. Ward 3 does have, some of these, and so I guess this is something I'm really curious about, particularly is the state and federal regulations for substance abuse clinics, are they now protected? Like you said, the definition of disabled now includes someone recovering from substance abuse, but is a clinic now also included as part of that?
No, so substance abuse clinic is a commercial operation that is
Okay.
a separate definition. That's different than being a protected group home.
So then, within this, it still says that these group homes can dispense medication and they have staff. So what's the distinction between, a smaller group home and a clinic?
Sure, so I'll just refer to the definitions because we do have a definition for group home and a definition for substance abuse clinic. But the clinic is the office or facility for outpatient or residential treatment, which can include dispensation of other controlled substances, therapy, management. It includes often, I mean, the business models that we get, because we, again, request in writing specific operations, that's where like the prescribing physician might reside, or the therapist. But in the group home setting, it's sort of the housekeeper who's, often a resident may not be allowed to hold their own medication because they wouldn't be allowed to dose themselves or have an overdose situation, or the staff in a group home is maybe helping with laundry or meals or something. There's just facilitating in a group home setting the family sort of residents. But the clinic is that. It's the clinical setting in which they're getting treatment. They're not getting clinical treatment in the group home setting where they're only residing.
Do any communities look at limiting the number? I know you have distance requirements, and I know this is where the Fair Housing Act, it probably gets a little blurry, but, given that housing is more affordable in Wheat Ridge than a lot of the surrounding areas, I mean, there is this potential that we could get more, right? Is there a consideration of potentially limiting him, to a certain, and I understand kind of you have to make this equitable, they're a protected class, but, if we already look at kind of where we're at, and we just anecdotally maybe know, or visually maybe know, is there anything you can do about that, I guess, or any thought about that, so that if I live in a residential street, I don't end up, with 3 on my block, and then one street over, there's 2, and, and then all of a sudden, by essence, I'm living in a multifamily neighborhood,
Well, a couple of
or a large Norwegian multifamily neighborhood.
a plethora of Norwegians can be, their own problem. A couple of things. At a base level, you have the spacing requirements, which which affects some dispersal, no question. Right. At 9 and up, you have the ability to special use permit and kind of look at impacts. But I'll tell you kind of bluntly that I don't find any support in federal law for saying, we as a community feel we have done our part, we have enough, and we need to be able to say no more. There's no support in federal law for that, and I would highly doubt that would be something that would be added to the federal law or that the courts would support. And I get it that some communities are more affordable and maybe lend themselves to that. There are communities that lend themselves to more college students because of what they are. Communities vary in their attractiveness to different groups, and the federal law would not support a limit in the way you describe.
And
As a city, reach a threshold and say, what we just said,
No more. No, there's not support in the federal law for that.
right, and so all the different distinctions we have with different types of uses, or like the Airbnb or pot shops, any of those things, it's because it's not protection.
Not a protected class under federal law, correct.
couple of things just to add maybe. So again, the purpose here is that the federal law has said there is a national, cultural, societal expectation and benefit to not discriminating against this group of people. For reference, 750, it's hard to sort of maybe picture, our shorter blocks in East Wheat Ridge, where we have sort of an intersecting street at every number, are about 600 feet long. Where they get a little longer, maybe Middle or West Wheat Ridge from like, say, 38th to 41st is like 1,200 feet long. So 1 to 2 per block, I think, maximum based on these separation requirements. And what, in just having spoken to some of these operators, again, their goal is to have residents who feel like they're in a residential setting. So often they're, we have operators in Wheat Ridge who operate numerous properties. It would be far more efficient for them to operate them boom, boom, boom next to each other, but their goal is to have their residents feel like they're integrated into a residential neighborhood and community, so they have chosen to spread those out. So I think, again, we don't try to micromanage through the zoning code something that can otherwise be self-managed by the market or whatever that demand is. I think we are working sort of in tandem with how it's functioning now. I hear what you're saying, like, is there a potential increase in this as we see more sort of concierge medicine or whatever is happening out in the treatment world? But I think we've struck a good balance between, the federal law, what we're seeing, how operators are telling us they're operating, sort of what our community, members are seeking.
Well, and I guess, so then my last question, I guess, is really looking at, you don't have a business license requirement, even though it's a company coming into your neighborhood, right? So like Morningstar could all of a sudden say, wow, it's a better deal for us to just come to these neighborhoods and like their business model could change basically. Or it could be a small business. I decide I want to do that, I'm very passionate. But right now there's no protection or check on that. And it seems like, I still want, I see the same people in my neighborhood, with the facility at my street. I do agree they're part of the community, but then what kind of check do we have on that? And I guess you're saying your solution is it the semi-annual, but why wouldn't it be a business license, I guess is my question. Since it is operating as a business, they're submitting to insurance, they're earning revenue.
Well, as far as I've been comfortable recommending the city go is this semi-annual or whatever, at whatever term. The creating a business license is then treating a group home for disabled individuals just on its face very differently than any other group of individuals in a residential setting. And I get it that it's a business. So, and I've gotten that question before, well, if it's a business, how come you can't apply the business licensing regulations to it? And my response has always been that to do that, especially up to 8, then really denies them the benefit of the federal statute, because you can basically say that we're revoking your business license. You have to apply your business license requirements then, and revoking the business license means that home isn't then allowed in that zone district. And I think the business license scheme has to fall in deference to the federal law for a group home up to that size, because you can't have both. And I get it that it means that there are operations that aren't the same as the natural family living next door. And that's because the federal law gives that protection. I'm now repeating myself. I'm not giving you an answer I know that you prefer to have, but I don't see it differently.
Most of our rental income is a business. Somebody owns it, they're making revenue, they're getting lease payments. We don't have a rental inspection program where we're licensing a property owner that's receiving income for people living there. And the presence of a licensing component invites the opportunity to discriminate, and that's essentially why it's not allowed.
Right. Well, and I think there's a pro and con to either approach, right? Is because I agree you could open the door to discrimination, but then if there are, if it's not being run well and to the detriment of the people living there, in addition to kind of impacts on the community, you don't have that check.
We've had the same conversations and challenges, because we're getting the same phone calls from neighbors who are dissatisfied. And my parallel is, and there are multifamily properties that aren't run well, that are poor. If there's a true issue, if there's a noise issue, if there's an illegal parking, if it's a disorderly house, the same rules apply to them, right? So it's not a free-for-all, but they have the same right to be there in that home, in that neighborhood, as any of the families residing on that street. They're held to the same expectation, behavioral, parking, crime, all of that. So the rules are the same. But they simply have the same right to be there as anyone else, and we can't create an additional hurdle for them to get there than we can for anybody else. Yeah.
Commissioner Zimmerman?
Thank you, Mr. Chairman. Excuse me. Okay, so in the proposed changes, first starting with section 2, and you start to define the different types of group homes. If I'm in group home for children, which is listed as A, and nursing home listed as D, specifically talk about licenses. B and C and now E, group home for disabled, don't mention licenses in their descriptions.
A, B, C, and D all end up with business licenses. In those cases, they also have state licenses that they're usually subject to. It's not always the same for B and C, but that code text is all unchanged from how it's been for quite some time.
Okay, so I'm sorry, A, B, and C currently do have licenses.
A, B, C, and D all get business licenses.
Okay, and E does not. Okay, so then it goes back to then, I still am confused about section 11, part B, when we talk about the sort of the semi-annual, I'm confused about letter C, evidence of approved and enforced state and county licenses.
Which section, where are you?
So I'm on page 7, which,
This certification again.
under B, under number 1, C.
Correct. It may be, the way this is this report, one of the things we're going to do is recommend that all group homes file a report, and we'll probably take this detail out of the code and migrate it to the form. Having said that, secondly, there are circumstances in which, while the city's not requiring a license, it may be that for whatever reason, the group home needs one from the state or the county. And you'll notice that we've said evidence of approved and enforced state and county licenses. That's sort of written a if any, because depending upon the other characteristics of the residents, there may be a county or a state license required, but it's not one the city's requiring. But, to the extent they've got to get another license for some other purpose, we would like to have that, and I think that's fair to ask.
I get it. It was confusing because I know what you were saying, that we don't want to have this group inequitable compared to the other.
And it implies that we're imposing a licensing scheme. And Dahl, I thought you just said that we couldn't.
Let me maybe explain to you what our business licensing process looks like, because I think it will demonstrate that is much more of an intrusion than this self-certification form that gets submitted. So for a business license, you have to fill out, it's 2 or 3 pages. Some of you may have done this for some of your home-based businesses. So it's your tax identification number, it's all your contact information, your property owner's information, full description of how you're operating. That gets submitted with a fee, and we look at it from a zoning standpoint. Are you permitted or are you not permitted? And then it goes to the building division, and it automatically triggers an inspection of the property. So a building inspector calls and schedules, and they come out and they look, and that may trigger a building permit. Your entrance isn't ADA accessible, this is a change in use, or your fire alarms aren't working. It's an intrusion. And in some cases, it's fine and there's no big deal, nothing has to change. But in other cases, there are upgrades that have to be made. So that's, and then we keep it and we track it and we collect taxes based on that license, and they have to update it annually. So it's a significantly more onerous process than just give us a form, 1-pager, every 6 months that confirms your population is still protected. We're not sending a building inspector into every new single-family home. We're not sending a building inspector into a group home for the disabled. So while it seems like it's the same, because aren't we just collecting data on a form in a database and mapping it and doing the same? From the way that our processes work, it feels different, and we will track differently, and we will sort of intrude at a much lesser level through the certification.
I get it. I didn't want it to be overly burdensome for this particular group. As you explain what the certification process is, I get it. but it was just confusing to me.
And that's a good opportunity for me to mention, did this get passed out? We, in the staff discussion, I think I mentioned at the beginning, we have come to the conclusion that if we're going to require semi-annual report, there's no reason not to just make that blanket for group homes. We think we'll probably have a section, that has to do with the group homes for the disabled, because again, you want the very important, yes, we qualify, because that's a fair question to ask, that you wouldn't be asking that particular question of others, and we'll have to figure out how the form reads. So what we'll be asking and suggesting you make as a recommendation to council that section get changed to require semi-annual certification to be applied to all types of group homes per a form approved by the city or something like that, rather than this detail, because this detail will vary a little as between a congregate care home and a group home for elderly, et cetera.
Any other questions? Commissioner Peterson?
Yeah, I want to go back to the definition of family. When I read this today, I was sort of thinking about gender in today's world, and the fact that it used to be considered a binary, and now it's a 2 or 3 dimensional space, probably. It's changed completely. And I think family has also changed a whole lot. And you both gave a very definitive definition of the family and how many unrelated people can live in a house. And you said this is enforced. But as I was reading this, I kept coming up with interesting situations, interesting combinations that I think are commonly nowadays seen as families, but wouldn't be covered here and wouldn't be allowed to live in a home together. I'm thinking about informally blended families, where 2 people decide to live together and each of them brings a couple kids into the situation. So you can have like 6 people living in a house. They're not married. There's no blood relationship across all 6 of them. And according to this ordinance, they cannot live in a house as a family.
They can.
Correct.
So this that definition and the occupancy limits, which is a separate section of the code, was labored over in 2012. The way that we explain it sometimes is and this is not maybe the most best application, but I've said this multiple times. Can you put 3 people in that scenario into a bowl or whatever that are unrelated? And there's no, and in that case you can't, right? You're always going to have at least 2 people in that room, club, bowl, whatever, who are related. So we enforce it very rarely, and it's very challenging to enforce for our code enforcement officers. But it's not those kinds of situations that are enforced. That would in fact be allowed, because it's.
But according to this, it's not allowed.
No, it is
The
allowed.
lawyers like to talk about the bright light.
So there's 3 people
seems
from
like
one
this doesn't-
family and 3 people for
The
another.
bright line, it doesn't hold up though, right?
There's 3 people in one family and 3 people in another, and you could never get 3 unrelated people in a bowl, right? 2 would always be related, at least.
Yeah, but it doesn't say that. Correct?
3 or more unrelated people are not permitted,
Yeah, 3 or more unrelated people are not permitted.
right? And in your scenario, you'd never be able to get 3 unrelated people.
What about
First 3 are
Two-
all related to each other, the second 3 are all related to each other.
but 2 lesbian couples who who unmarried decide to live together? 4 people.
Right.
Would you tell them they couldn't live in a single house?
4 unrelated people, not related by blood, marriage, or adoption, correct?
Right, it's just 2
It'd be
people who
4
cohabit
roommates.
as a lesbian couple and another 2 people who cohabit as a lesbian couple. This says they cannot live together in the same house.
Right.
You comfortable with that?
That's not my decision to make, or Mr.
Well,
Dahl's.
In a way, it is.
2 things around this. If Planning Commission wants to make a separate recommendation on the definition of family unrelated to compliance with the Fair Housing Act amendments, and wants to communicate to council that they think that there are some familial living arrangements unrelated to this, the problem we're solving here today, then fine, and do so, and we'll absolutely take that to council. And they can have what amounts to that social policy discussion, which they have power to regulate. Denver, has addressed similar kinds of issues, not the same one you describe. And I'm happy to get whatever direction from council, and they can further amend the family definition. I think it's probably fair to say that the number of times that circumstance, comes up is probably rare, but we write things for rare circumstances all the time. It doesn't bother me at all to have that discussion and have planning commission make a recommendation. But my suggestion to you is if you want to make that recommendation, it's one separate and apart from the group home ordinance revisions, and make a separate motion and we'll take it up.
No, I understand this is separate from the group home ordinance, but this appears in the same change in the ordinance. The definition of family appears in the same change.
Sure, and a lot of things, with no pejorative intent, a lot of things do, but all the sections here had to be amended to service the group home job or task.
I understand that.
There's all of these sections do raise other topics, and if you want to make a separate motion after you've made the motion on the ordinance, the definition of family should separately be addressed for this purpose, then I think you should.
Okay. May I just add a couple more questions? The 3 or more persons, we talked about that, 3 or more unrelated persons. Why is it that 3 or more unrelated persons, that only 3 or more unrelated persons under the age of 60 can live together, but if you're 60 or older, 4 or 5 can live together?
I think there's something in our charter that relates to that too. But it's essentially a nod to the, you're not quite a group home, but you're not impactful like another group of people. That's been in the code for as long as I'm aware.
Yeah, the city has always kind of given small collections of elderly sort of a break. And that's an example, frankly, of a break they can give or not give to the elderly, because the elderly are not a protected class under any of these statutes. And so just like cities give a break to a larger or smaller number of unrelateds, in a college town, I'll bet anything the numbers go up because you can, or you can be hard on college kids because they're not in a protected class either. They probably think they are not in a protected class either. The tradition in Wheat Ridge has been to give small collections of elderly kind of a break.
Okay. And in the state of Colorado, is there a growing domestic partner case law?
I don't know. I mean, there probably is, but it's not in my head. It's probably easily researched, but it's not something I carried in today.
It seems to have a direct bearing on definitions of families. So I think this all came into my mind because in my previous life, I had to deal with the definition of a family because of federal guidelines for something. And it had to do with what is a family. And so I don't know if it's, I don't remember what it was. That's what brought this all to mind.
If there's an issue the Planning Commission thinks council ought to address around the definition of family separate and apart, then if you can articulate it, they'll, send it to them.
Okay.
And they'll put it on a study session or not, as they, choose. And just as they did this, and good for them for doing it. I forget whose question, I think perhaps it was yours or someone's question, maybe it was Commissioner Larson's, why did we get here? They heard from residents, and then they, these things get on their radar screen in various ways. You know how that works.
I was here in 2012, and very quickly, I remember the problem about there was a home. It wasn't a licensed group home, but there was just a lot of people coming in and out and unregulated, and so that was the neighbors had an issue with that. And then staff did some comparisons on why. I know for a fact when I lived in Fort Collins that not only was it no more than 3, that when I went to sell the house, you had to sign a document that you weren't knowingly selling it to somebody that was going to be 3 or more unrelated. And the buyer had to sign another agreement saying that this was not going to be more than 3 or more unrelated. And it's a college town. And because they didn't want, it had to do with the neighborhoods of having too many kids in a house and too many cars parked, and that was the problem, the context of that.
But here, there's no rental ordinance. So if I own a second house and I decide to rent it out, the only control I have over how many people I rent it to and what their relationship is to one another is if the neighbors complain, correct?
Right, I mean, this is essentially enforced on a complaint basis where you have enough probable cause to find evidence that there are more than 3 unrelated people. It's infrequent, and it's usually extreme case situations.
So going down that, the question I have is the language about the persons in recovery from alcohol or drug. So as I kind of look at what the code says, as far as it says it's a little bit different, but it says particularly, and this is on page 3, particularly as they relate to recovering, not presently using alcoholics. I've met a lot of people, and one of the first things I've had some people tell me is that I'm a recovering alcoholic. This isn't a 2-week stint. They're recovering alcoholics for life, is my understanding. They wouldn't say that, well, I recovered and now I'm done. They're recovering alcoholics for life. So if they're recovering alcoholics, as related to recovering, it doesn't say treatment, it says recovering. If they're recovering alcoholics for life, is there anything to stop someone then to say, well, I'm under the federal guidelines. Someone buys the house. It could be a company. They rent it out to 8 people that are recovering alcoholics. They're not going through treatment, but they go to AA and they're recovering alcoholics. Is that some type of loophole? Is that?
Well, let me address that. Let me address that. You're right in saying, and the law is, that to be within the protection of the statute as an alcoholic or drug addict, you need to be in recovery, not presently using. And you're right in saying that. You're also right in saying that you are recovering for life, and so therefore you have that disability for the rest of your life. And it is true that if you've been sober for 10 years and you want to go out and find 8 other people that have been sober for 10 years and live together, then you are entitled to the protections of the statute. I can tell you that I would think that circumstance is really pretty rare. If it's a loophole that the law allows. And I keep referring back to the conversation I had with Councilmember Urban. With the greatest respect, if that becomes the problem, and there are now 10 homes with each of which has 8 recovering alcoholics that have been sober for 10 years, that's allowed by the law, and I don't think it's creating a problem. It may be a loophole, but I don't identify it as a problem that requires solution.
So you wouldn't recommend changing recovery to something that has treatment currently?
No, I would not.
Treatment, you can't say?
No.
Okay.
No, I would not require someone to get the benefit of I wouldn't require a disabled person to tell me that they are receiving treatment in order to receive the benefit of the law applicable to disabled persons. I would never do that.
Okay. The other question I have is the horizontal separation, is that similar to the marijuana laws that we currently have, and that my understanding is that it applies to marijuana establishments outside of the city limits, correct?
Marijuana explicitly does. We have several separation requirements in the city, and they don't. So separations from drive-throughs or self-storage or auto sales. And this, likewise, none of those would apply outside the city limits because we haven't explicitly said so, in the
What I
same
mean
way
is
that we did
there's
for marijuana.
If there's a marijuana establishment, I'm just talking about marijuana, if it's outside the city limits, in a marijuana establishment, we have one in City of Wheat Ridge, can they be right there, right in the property line next door to that one?
No, but because we explicitly codified that the separations apply extra jurisdictionally,
Okay. Is that the case for this one? Does that,
not for any of the other separation requirements in Chapter 26.
okay.
Yeah.
That's all the questions I have. Thank you. Are there any other questions for staff?
I just want to clarify, we're looking at deciding if we're not deciding if substance abuse persons are protected class. That's already been established.
That's right.
We're just deciding if we're approving the proposed ordinance.
Yeah, recommending to the city council that
Right.
that you recommend it's, that's exactly right.
Okay, I just wanted to clarify that.
Yeah, you're not making the decision that that recovering alcoholics or drug addicts are or not entitled to benefit. You know, that the federal statute made that decision, and lots of federal cases since have taken care of that for you.
Okay, so they are included in this,
Protected class.
okay.
That's correct.
Did you have a question?
One last question. I believe I may know the answer, but I want to ask it anyway.
We're going to ask you to provide the answer as well, so that we're
Fair
not
enough.
trapped. So go ahead.
Condominium homeowners associations are afforded some special things that, in terms of being able to qualify buyers and having some control over people that live within the HOA. Would they be exempt from any of this? I know we're talking about a federal amendment here, but
that's a creative question. Now, what is your answer, by the way? You said you thought you did have one, so let's hear it.
I think the answer is no. I think they would not have the right to deny a group home.
Primarily, those are private covenants. I'm thinking out loud here, but they're private covenants the city and the government does not enforce. The answer, I think, would be whether and I wish I had the FHAA here with me, that statute, because it's a violation of the FHAA to deny a reasonable accommodation or, accommodation to the program, deny that access to the program, and we talked about what the program is. But that program is a government program. I'm trying to think if the FHA, I think it does. I think it applies to private industry, but the more I think about it, there's a separate division within that statute. Here's the rules for governments, which is our rule and what we're doing here. Here's rule for private industry, and it's a little different, I think, probably as it should be, but I can't remember now whether we would just apply the rule we're talking about. I'm just not sure. That's one of those kind of research questions that I. Sure, and they do all the no, certainly not based upon race, gender, etc. That's unequal protection of the laws becoming a constitutional violation. the protected classes under the FHAA are not constitutional protections, they're statutory protections. That's where your gray area. Yeah, I think so. Question for another day, and I'm sorry that I don't have a full answer, but I'm glad that it's not one that implicates this ordinance, because then I'd have to have the answer, but I don't. Sorry.
Are there any other questions for staff? Yep.
It's just a question of procedure. Mr. Dahl, you mentioned if we wanted to make a recommendation on this motion. And my personal view is Section 11 could be reviewed. How could you help word what, or does that happen in the motion, or does it happen outside of the motion? What's procedure?
Yeah, so our staff recommendation would be that we revise the ordinance so that that certification is not unduly burdening only group homes for disabled and applies universally. Tammy has a revised recommended motion that would make that language more available to you.
You asked it at absolutely the right time, so thanks for doing that. And if there are other things you want to tell them about the ordinance, add it to that handout, and we'll take it to them.
Any other questions? Okay, I will now open up the citizens forum. There is no one in the audience, so I will now close the the citizens forum. At this time, I would entertain a motion.
Mr. Chairman, I move to recommend approval of the proposed ordinance amending Chapter 26 of the Wheat Ridge Code of Laws concerning residential group home and substance abuse clinic zoning requirements with the following amendment to the ordinance. 1, that a semi-annual certification be applied to all types of group homes.
Second.
Any discussion? Call for vote.
Motion carries 8-0.
Thanks. I really appreciate your time on this, and I especially appreciate your tough questions, because they were the right ones to ask for the protection of your community. And, what we have here is as we often do, and as you often do, the sort of tension between, the needs of the community, protection of the community, and the constituents that you see every day, and the requirements that are laid on us as government. And we're always navigating that, aren't we? And we're always compromising a little in one interest to the other to try to get both of them served. And it's hard work. And so thanks for your participation in that. I really appreciate it.
Thank you. Yes? Do you want to move on to old business? Or new business, or what? Yeah. Okay, is there any old business?
One thing, Mr. Chairman, Lauren, if you wouldn't mind providing an update on Wheat Ridge Speaks. I know we talked about it at the last meeting, and we were told that we would receive some instructions in January. This is January.
It is?
I haven't seen anything.
You're right. Tomorrow is when wheatridgespeaks.org goes live, and when all decision makers receive an email with their login and guidebook. Next Friday, the 24th, is when it will be populated with our first case, accepting public comment. So, tomorrow. Tomorrow it goes live. Mm-hmm. And you'll send instructions in an email tomorrow. Yes. Yes. I have been working furiously on that launch, and we will be live by midday-ish, and you'll get an email by close of business. Yes. Sure, yeah, that question's come up a bunch. Regular marketing, social media, newspapers, Mayor's Matters. Mayor wrote a letter about it. We did a press release. We will have, and I'll put this in the email tomorrow, we have made business cards that are in production, so all of you and all council members, when you're in a grocery store and someone wants to talk to you about a case, you give them this handy business card and say, I can't talk about this case, but you can submit your comments here. Has the website on it. I think it will grow organically. At some point, we're not doing sort of a mega marketing push because we don't want certain cases to have the advertisement of Wheat Ridge Speaks that other cases don't, right? We're trying to treat quasi-judicial cases in a uniform way. So we're doing our big push right now. All of the noticing letters that get sent to anybody who receives a letter within 300 feet have been updated to include the wheatridgespeaks.org. All of our posting signs that are yellow now have a big black and white QR code, learn more and comment online, wheatridgespeaks.org. Our website has been updated. The calendar event for any city council or planning commission meeting will say 3 ways to participate in a public hearing. Come, view online, or comment online. So we've tried to sort of disperse it in a lot of different ways. We'll have postcards in the back of council chambers, a couple of desks around the city. Yeah, we tried to do it pretty broadly, but I think it will grow organically as people get letters. You know, they want to know sort of what's the easiest way to comment, and it'll be in that letter. Yeah. Thanks.
Any other old business? Okay, let's move on to new business.
My only new business is resolution number 1 that we forgot, it was January. Every year, every board of the city is required by state statute to approve a resolution that officially designates the posting place for public meetings. For all boards within the city, that location is our city lobby. Sometimes what catches people's attention is the 24-hour notice. That's a minimum requirement. For example, you couldn't have an emergency meeting without at least 24 hours notice. We also post and publish all of our public hearings in the newspaper, on the website, and 2 weeks in advance. But again, this is just a minimum requirement establishing the lobby as the official location and in compliance with state statute. So all we would be asking for is a motion approving resolution number 1.
Is there a motion?
A question?
I move we approve resolution number 1.
Is there a second?
I had a question.
Is there a second?
Second.
Okay, any discussion?
Why in this particular case, number 1, are you not including the newspaper?
So we do, that's required by city code, but this is sort of a minimal requirement in compliance with a different state statute. So our official designation for where we always post the agendas for meetings is the lobby. And all of the, what's that?
And the website.
I think this is,
This is.
yes, yeah, thank you. The lobby, the municipal, and the city's website, yes.
Thank you.
Any other discussion? Call for vote.
Motion passed 8-0.
Is there any other new business?
I had a question. Staff report on this first item we heard about, page number 3, next steps. At the bottom of the page, the Planning Commission recommendation will be forwarded to City Council.
Yes.
I wanted to know, is that just a recommendation of the word approval? Or is that the full minutes with discussion and questions and answers? Does the City Council get that?
Yes, so every first readings do not include that, but the second reading for any city council always includes the Planning Commission minutes with it. In the text of the council action form says what you're recommending and what conditions, and then the full minutes are an accompaniment, an attachment to that
At a different time?
at the public hearing.
A second reading.
Right. Why does council not get to hear our discussions at the first?
The first reading is usually too fast, so first reading can be as quickly as next Monday. And there's no discussion, they're not reviewing the case
That's true.
substantively, they're just setting a public hearing date.
You know, they have that universal rule, you know, no testimony or anything on first reading. The first reading's function is just to set it for hearing.
We don't usually include any attachments, really, with the first
Okay,
reading.
thank you.
My only other new business is just dates. We do anticipate having both February meetings of the Planning Commission.
6th and 13th, 6 and 20?
Yes, 6 and 20.
Just for the record, then I will be out of town for the 6th.
Okay. Nothing else for me.
Anything else? Is there a motion to adjourn? Second?
Second.
Discussion? Call for vote?
Motion passed 8-0.
Well, that was interesting.